Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 176 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I'm an employment solicitor and I run the firm Real Employment Law Advice, where we provide advice and assistance to both employers and employees. Now, for those of you who are regular listeners, I must apologise for the 2-month break in the podcast. I hadn't anticipated it would be this long and I hadn't really planned ahead, but it got to the school holidays and with work and children and colleagues being off on holiday, it just became too much to try and get the podcast done at the same time. So I decided to take a break and I'm back again now with the episodes out fortnightly. So hopefully we'll keep to a consistent schedule now until Christmas. But yes, we had a bit of a break over the summer holidays. It was quite busy with employment tribunal matters and various work for our business clients. So it's good to be back with the podcast. And in this episode, I'm going to be covering the end to furlough and self-isolation rules. Now, I'm really hoping that this will be the last time that I'm talking about furlough on this podcast. I'm recording this on Tuesday, the 14th of September. And I'm conscious that there is due an announcement this evening from Boris Johnson about the future with regards to the planning for COVID. Hopefully they don't announce that furlough is going to be continuing or there's any changes in relation to this. But if they do, of course, I will cover it in the podcast and I might find myself re-recording this tomorrow morning. But there we go. So here we go. Without further ado, I'm going to get into this week's featured content. As I was saying, my plan is to cover the end of furlough and also some information about the changes to the self-isolation rules, which I think employers need to be aware of. So firstly, as we know, currently furlough is due to end on the 30th of September. It's the cut-off for this scheme, so it means that after that date, employers will no longer be able to access the additional financial support in relation to staff. Now, what this means in essence is that you need to plan ahead. You need to look at what you're doing if you haven't already and decide what you're going to do in relation to those staff who are furloughed or flexibly furloughed. Now, there are a number of options available to you, which I will cover off. But really, as I say, it's about planning ahead and understanding that you will no longer be able to access that financial support. So the first option you have is, of course, to return them to work on their pre-furlough contract terms. So what you will have done, as we've talked about in the past, is you will have altered their employment terms temporarily by agreement so that they are either working less hours or not working at all and receiving less pay for the time that they're not working. So you would just return them to the same contract terms that they were on before the furlough scheme started, before the lockdowns. So that could be the normal full-time hours or whatever hours they were working and the pay. The second thing is you could consult with them and agree an amendment to their contract terms so that you make an amendment on a permanent basis. So, for example, if you need to reduce their hours because you no longer have the capacity or you don't have the finances to pay them for their normal hours, you could agree with them to reduce their hours. You need to be careful here if you are reducing their hours or changing their terms significantly, because if an agreement isn't reached, you might find yourself in a redundancy situation. So it is important that if you're going to go down this route, that you really consider it, think about if it's going to be agreed and get some advice if necessary. That leads me on to the third option, which is, of course, if unfortunately you cannot return staff to work or you don't have the work available, then you can go down the route of consulting with them and starting the redundancy process. So if you need to reduce the number of staff and reduce costs or significantly change terms and conditions, then you can go down the redundancy consultation route. Now, I do cover off redundancy in quite a lot of detail in the podcast. If you go to episode 147 of the podcast, there is a mini-series on redundancy there, which covers all of the things you need to know. Also, if you need to make redundancies, we have developed a DIY product for you. So basically all the documents and letters that you might need, as well as guidance and checklists in relation to the redundancy process if you're planning on doing a redundancy by yourself. You can find that on the website, which is realemploymentlawadvice.co.uk, and it's in the DIY documents section, which I'll put a link to in the show notes below. But in essence, if you're going to go through a redundancy process, you need to get started as soon as possible, because depending on the number of employees that you are intending to make redundant or intending to change their terms and conditions, you may have a minimum period of time in which you have to consult before you can actually make those redundancies. The fourth thing that you can do, and it's something that I'm not sure that people are really thinking about, and obviously it may not be realistic, but that is you can of course agree to keep them furloughed or flexibly furloughed for a further period if you need to. Of course, you won't receive any payment from the government, so you will be funding that yourself, but you could agree with a member of staff, for example, to keep them on a flexible furlough whereby you pay them a percentage of their normal wage for the time that they're not working. That may be a temporary solution. I understand obviously there's a cost to that, but if, for example, you need to retain a member of staff and you know that there is work coming up, then you could potentially agree that rather than make someone redundant or lose them. So it is an option for you. And I just want to remind everyone, which I talked about previously, which is the furlough scheme that you claim from the government is different to your relationship with the employee. What you can claim from the government is set out by law, but what you can agree with the employee in terms of their employment and terms and conditions is between you and the employee. So you can make changes to the contract, you can agree certain things with them as long as it's agreed between you. The problem arises, of course, when it's not agreed, but there are various options available for you. So what I would suggest you do is, if you are coming to the end of claiming furlough, if you've been relying on it right up until the end and you need to think creatively about the future for your business and your staff, then open a dialogue with them and really start to think about what can be agreed between you so that the staff keep their job and are happy, but you also keep those resources and can keep the business going. The next thing I want to talk about with regards to the end of the furlough scheme is planning ahead in the event that you have to close your business for any period of time. Now, here on the Isle of Wight, and I know it's happened around the country as well, there have been a number of businesses which have had to close for a short period of time, either because they've had a number of staff out in isolation and haven't been able to staff the business, or because there's been a COVID outbreak amongst the staff and they've had to close completely. Now, in that situation, currently, employers are able to access the furlough scheme, so you can furlough those staff who you have to stand down because you've closed the business. Obviously, if someone has COVID or has COVID symptoms and is unwell, then you can claim under the amended statutory sick pay scheme so that you pay them statutory sick pay. But for those staff who don't have COVID and are well enough to work and who have guaranteed contracted hours with you, if you have to close and you're not able to provide them with work after the 30th of September, you need to think about what you're going to do in terms of paying them, because you will have a contractual obligation to provide them with work and to pay them. And unless the employees agree that they will have no pay for a period of time, then you could find yourself facing a claim for unpaid wages or even for constructive unfair dismissal if they decide to resign and claim that you've breached their contract fundamentally. So what you need to do is have a look at your employment contracts, because you may already have short-time working and layoff clauses contained within those contracts. Now, if you want more full information about layoff and short-time working as options for you, I covered this in episode 142 of the podcast, so you can go back and listen to that. And again, I'll put a link in the show notes. In summary, basically what a layoff or short-time working clause is a clause within your employment contracts with your staff that enables you to stand them down or to lay them off for a short period of time or to reduce their hours. And by doing so, you won't be in breach of your employment contract terms with them because you have that contained within it. So layoff and short-time working is an option if you have to close your business, as long as you have that in your contract terms already. If you don't have that, and it's too late to start consulting to change that, then there are another few options available to you. Of course, you could start a consultation, introduce that new clause and change staff contracts now and plan ahead. Certainly you can get that underway. But there are a couple of other things you can do as well if you didn't want to introduce that, or if it couldn't be agreed with the staff or the unions. The first thing is obviously reach an agreement with staff about what will happen. So open a dialogue with them and perhaps decide, for example, that you would pay them 50% of their normal pay in the event that you have to close for a short period, and that could be up to a maximum of 2 weeks, for example. And again, you can agree that with them in advance. It's much better to do that than rather panicking when you do have to close. The second thing you can do, as I say, is to look to change the employment terms to include their clause to enable you to close or to lay them off or to put them on short-term working, so reduce their hours for a period. And the third thing you could do is to make a contingency plan. And I recommend you do this anyway. That is so that you are able to continue to operate and reduce the possibility that you have to have a forced closure. Whilst it might seem obvious, there are some things you can do to prevent the need to have to close due to COVID. You could, for example, have 2 separate shifts so that the 2 shifts of staff don't cross over. So if one shift goes down with COVID, you still have another shift available to undertake the work so you can keep the business going. So therefore sort of creating different bubbles of staff. You could collaborate with another local business and agree to do a staff share in the event that one of you has a shortage due to COVID. You could, of course, keep key personnel working separately. So if you can't have separate shifts of staff, you could say, well, actually, the business really needs this person to operate and this job role. So we've got 2 people doing that. We'll make sure that they aren't crossing over so that if one of them's taken out, the other one isn't. And therefore you're able to safely operate and continue the business. So look at ways in which you can avoid the need to have to close in the future. As I say, I'm sure you're already doing regular COVID risk assessments, updating them and making contingency plans, but just a few ideas there, and to hopefully get you thinking about what you're going to do when the furlough scheme is no longer available to fund wages in the event that you have to close. Of course, if you have any questions about this, if you're planning ahead, you're looking to make changes to employment contracts, or you just want to check your employment terms to make sure that you have the flexibility there, then do not hesitate to get in touch. That's what my team and I do on a regular basis for businesses. We work with a number of businesses on a daily basis in relation to these sorts of things, so we can certainly help you. Do not hesitate to get in touch. You can email me. My email is alison@realemploymentlawsadvice.co.uk. The second thing I wanted to talk to you about on the podcast today is the changes to the isolation rules. And no doubt you're aware of them because they came into play on the 16th of August. So it meant that basically those people who are a close contact of someone with COVID do not need to self-isolate if they have been vaccinated. Those who are under 18 or haven't been vaccinated for medical reasons are also covered by the self-isolation exemption. So it means that a member of your staff could have someone at home who has a positive COVID test, and the employee does not need to isolate if they have had their double vaccination. So this means that there is a potential risk that the person who is the close contact of someone with COVID could be at risk of having COVID themselves and also spreading it amongst your workforce. Now, the guidance from the government states that they are advised to get a PCR test as soon as possible and to take additional precautions such as wearing a mask and limiting contact with others. Now, I know from experience from a friend of mine who was pinged by the NHS app that they were then booked in for a PCR test straight away. So it's advisable that at the very minimum, you put in place steps with your staff to ensure that if they are a close contact with someone who has COVID, that they obtain a PCR test as soon as possible. But it's not as simple as that, unfortunately, because there is no obligation under the law for an employee to tell you that someone in their family or someone that they live with or a close contact has a positive COVID test. So it's really important that you spell it out to staff that the expectation is that if they have someone who's close to them who has COVID, or if they are pinged, that they notify you so that you can take steps to mitigate any risk to others. If somebody is required to isolate, they do have a legal duty to inform you. So if they are required to isolate, so they're not covered by the self-isolation rules, they have to tell you, and it could result in a fine for them of £50. But as I say, those who are exempt from self-isolation don't need to inform you unless you set it out clearly in your own rules and procedures to them. So what should you do in order to minimise the risk to your business as a result of these changes? Well, you should consider what steps you need to take to mitigate the risk. So if somebody has a close contact who is positive for COVID, can they work from home? And are you going to require them to work from home in that case, in the same way as they would have pre the 16th of August? If they can't work from home, are you going to ask them to have a clear PCR test before they return to work? And if you are going to ask them to have a clear PCR test, what are you going to pay them while they're waiting for that test? Because of course they're fit and able and ready to work. And if you were asking them not to attend work, then you would need to pay them for that period of time. You need to update your risk assessment to make sure that it covers the change in the rules in relation to self-isolation. And my advice is to communicate whatever decisions you've made in relation to this to staff and set out what your expectations are. Again, it's really important that you make a decision for your business that's based on a risk-based approach. So what is the risk for your organisation? And then take the steps accordingly. But here are a couple of ideas for you. The first is, of course, as I said, you can require double-jabbed employees to have a PCR test before returning to the workplace. You can require them to work from home if they can. You can ask them to take regular lateral flow tests. So if, for example, you're already having lateral flow tests regularly for staff, you could increase the frequency in which they're required to have them if they've been in close contact with someone who's had COVID. You could ask them to return to wearing a mask if they've had a close contact, or you could move them to work in another area so that they are further away from other staff and prevent possible risk of spread. As I say, you need to think carefully about how you're going to play this and what you're going to do, because you might not have had any situations where an employee has a close contact with COVID. But moving forward, as we move into the winter, all the predictions are that there will be more frequent cases, so it's more likely to arise within your business. And you need to seriously consider what you're going to do with those employees who haven't had the vaccine. So those people who have chosen not to have the vaccine and therefore do have to continue to self-isolate. What are you going to pay them, and how are you going to communicate that to them, the difference in relation to them and their colleagues? I've talked about making sure staff are aware of the rules and your procedures, but I think it's particularly important to communicate that to those staff who haven't had the vaccine or have chosen not to. What are you going to do if they have to isolate, and what are the expectations of them to tell you exactly what's happening? Now, of course, there may be those members of staff who still haven't had 2 vaccines because of their age, for example. Maybe they're one of the last ones to have had the opportunity to have the vaccine and therefore are still required to self-isolate. You need to be careful about how you're dealing with those, because those people have not been able to have 2 vaccines, not by choice, but because of their age. So it's important that you make sure that you're not implementing anything that might be seen as being discriminatory or putting them at a disadvantage. The key thing in relation to dealing with staff who have decided not to be vaccinated by choice is to maintain communication with them, understand that they have different views, and balance the risk between colleagues, customers, and the business versus being a good employer and being reasonable to those people. So to summarise, the steps I think you need to take in relation to the change to self-isolation rules are to check your risk assessment and update it to cover exactly what your expectations of staff are and how you're going to reduce the risk to your workforce and customers. Communicate that to the individuals and decide what steps you're going to require somebody to take who has been a close contact of someone with a positive COVID test. If you would like any advice on this, or if you'd like some suggested wording in relation to what to issue to staff, then we'd be happy to help with this. Please don't hesitate to get in touch. You can email me, it's alison@realemploymentoradvice.co.uk, or if you prefer to phone, you can phone the head office on 01983 897 003, and one of our solicitors would be happy to chat with you. And of course, if you have any further questions or anything you want covered in relation to furlough and self-isolation, then please leave a comment with the show notes or on the website or wherever you're listening to your podcast. Thanks very much for listening. It's fantastic to be back recording the podcast, and I look forward to speaking to you again in 2 weeks' time. Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you that the information in this podcast is for information only. It's general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.